Committee Room 30. Signed. 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 Committee Room 30. Committee Room 30. Signed. 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 Committee Room 30. Committee Room 30, Sound. 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 Committee Room 30.
To the public, can I welcome members to the 78th meeting of the Committee for Justice? Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that the oral evidence session with the Northern Ireland Human Rights Commission on the sentencing bill will be recorded by Hansard and seek their agreement for this? Is that okay? Mm-hmm. Can I remind members that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration. Any members who have interests to declare in relation to today's business should do so now or when the particular matter arises. So can I ask members if there are any interests to declare at this stage? Okay.
APG we usually declare.
Just the membership of the APG on the justice, access to justice. Mm-hmm. Okay, thank you very much. I'll take that. Sorry, Morris, you want to come in?
I forgot, Chair, to declare that I'm a member of the APG as well.
Okay, no problem. That will be right across the board, every member. Yeah, MSC you indicating, and all members too who sit or are members of that APG. Okay, members, I'm going to make a statement now on behalf of the Justice Committee. As Chair of the Justice Committee, I want to place on record the Committee's condemnation of the violence that is visiting our streets at present, and to express the Committee's endorsement and support of the statement that was issued by the Northern Ireland Executive, and to acknowledge the statement of the Ogilvie family. We'd also want to place on record our thanks to the emergency services, the PSNI and the Fire and Rescue Service for their efforts, and we send our very best wishes to all of those who have been impacted negatively as a result of the sustained and unnecessary violence. Thank you very much, members. Agenda item number 1 then is apologies. Have we any apologies?
Chair, Patsy's running late.
Patsy's running late. Okay. And can I advise members then that committee members Emma Sheeran, Morris Bradley and Aoife Finnegan are attending the meeting virtually and are on the screens. Agenda item number 2 then is draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday the 4th of June 2026 are at pages 5 to 16 of the meeting pack? Can I ask members if they are content with the minutes and they are a true reflection of the proceedings of that meeting held on the 4th of June? And if so, I will sign. Members agreed? Agreed. Over the minutes. There is that minutes there. Okay, agenda item number 3, matters arising. Can I ask members if there's any matters arising from the minutes they wish to raise at this stage? It's not on the agenda. No. Okay. So agenda item number 4 then is the Criminal Justice Sentencing etc. Bill, Northern Ireland Human Rights Commission oral evidence. Can I refer members to pages 18 to 44 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from the Northern Ireland Human Rights Commission on the sentencing bill? Can I inform members that the witnesses providing evidence today is Alison Kilpatrick, Chief Commissioner, Dr Claire McCann, Senior Policy Researcher, and Emma Osborne, Policy and Research Officer. You're very welcome to the Justice Committee. Thank you for attending this meeting. And can I invite you to make the opening statement? Alison, thank you.
Thank you very much. It's our pleasure to be here, and thank you for the opportunity. As the committee will have seen, we welcome the bill, which has been a long-standing recommendation of the Commission. We focused our response on Part 6, pertaining to the statutory hostility aggravator, which in our view was where we could be most helpful. We note the decision not to introduce a statutory definition of hate crime or hostility, and remind the committee that states have an obligation to ensure that individuals and groups are protected from harm. To have a statutory definition for both would provide greater certainty for victims and perpetrators, it would be more easily and reliably enforced, and it would enable better data collection. We are of the view that for reasons of transparency and effectiveness, the definition should be contained in legislation, not left to guidance or secondary legislation, although the latter is preferable over guidance. The Commission notes there is a narrow list of protected characteristics: race, religious belief, disability and sexual orientation. Excluded, for example, are sex and gender identity. Evidence identifies that attacks motivated by hostility towards people based on their sex and gender identity are on the increase. We urge the committee to explore amendments to the bill which include these grounds. We also note the absence of hostility motivated by sectarianism. Under the sentence enhancement for hostility, sectarianism was occasionally dealt with under a combination of the existing grounds of racial and or religiously motivated hostility. So we've recommended the committee satisfy itself. This will be the same approach under this legislation in the absence of a statutory aggravator for sectarianism. Our response also raises concerns regarding the absence of a by reason of threshold for the new offence. In the course of our own investigation on racially motivated hate crime, concerns were raised about the effectiveness of the thresholds of demonstration of hostility and motivated by hostility. It's our view that the by reason of threshold better reflects the harm done to victims and their communities targeted by reason of their immutable characteristics or identity. We also note the use of the by reason of vulnerability based on, for example, age at clause 36 of the bill. We fear it may create a discrepancy in treatment between victims at clause 33 and 36. We take the opportunity to highlight the importance of the collection and regular dissemination of robust, disaggregated data on the new offence to ensure effective monitoring. And we recognise that the PSNI produces robust data on hate crime already. However, we're keen to see this new offence is effectively measured at all stages of the criminal justice system to better help the PSNI and everyone else within the criminal justice system, and to show victims that such offences are taken seriously. I'll leave it there. Thank you. Okay,
thank you very much for that succinct presentation, Alison. It's always very helpful when people can be so succinct and timely, so thank you. Can I ask questions then on, obviously the bill as it's laid out in clause 33, the department have put in the 4 areas: racial hostility, religious hostility, hostility related to sexual orientation, or hostility related to disabilities. And then of course that leads on to part 2, which is racial group, religious group, sexual orientation group or disability group. What in your mind is different between sexual orientation and sex?
Sex is the sex of the person, male or female. Sexual orientation is their orientation. So in other words, same-sex couples would be included. Or in fact, heterosexual couples if they were targeted by a same-sex couple.
Right, okay. So that's, you see there have been a big difference between sex as identifier and sexual orientation as identifier. And gender identity then, added in, is that different from sexual orientation?
It is. So gender identity is the identity, how the person identifies themselves. We have not gone so far as to say self-identification, but we stick to gender identity, which is used in the European Convention on Human Rights, Article 14, which is the protection from discrimination.
Okay. Can you elaborate then, because you did mention it, about the using age as a vulnerability in 36. Can you elaborate that for me? I didn't quite catch it all, and how that could cause offence to or violence to 33.
Sorry, if that's the way it sounded, that isn't what I was. No, that isn't what I should explain it more clearly.
Okay.
It's that we say in 33, by reason of should be also included. It is included at 36. And the same reasoning for including it at 36, which we think is a good reason to have it at 36 for age, could also apply to 33. So there are differences of opinion, just to be absolutely clear, about whether or not a vulnerable minority should be protected differently or should have a different form of enforcement. We think by reason of applies in both. So it's not that we think one is better protected than another, it's just that we think the same should be, a threshold should be applied for both. It shouldn't take away from either.
And in 36, is age, so it's vulnerabilities, but is age mentioned in it? Forgive me for not having read it lately, but...
Yes.
Or do you translate vulnerability as age?
No, age is specifically mentioned. So for example, and the difference, maybe this is a better way of putting it, if somebody is targeted because they're vulnerable, it can simply be because it's easier to commit crime on that person.
Yeah.
So that could be an older person or a very young person.
Yes.
Under Section 33, it's targeting somebody because you have a hostility towards them and their immutable characteristics, their personal identity or the colour of their skin, for example.
Yeah. So basically, 33 is aggravated by hostility, basically aggravated by hate of a certain person because of their certain...
Exactly.
And 36 is an aggravation by reason of their vulnerability, so they have been attacked simply because it was easier to do so, in my words.
I must say, I mean, there's a debate about which falls into which category,
Yes.
and I think the PSNI may have a view about how easy this might be for them to enforce, because ultimately I think that's going to be one of the tests. But whether or not somebody is targeted simply because it's a greater opportunity, or because they're vulnerable due to an old age, I think I think the jury's out in relation to whether one is a hate crime, one is simply a vulnerability. But
Yeah.
it works both ways.
Sure. And so 36, if I read part 1, it may be specified as an allegation alongside a charge of an offence against the person A that the offence is aggravated by reason of the victim's vulnerability. So how important do you think that by reason of actually is? And why do you think it's been left out of 33?
There are different views on it. There are some victims groups, I think victim support, and I argue that it should be separate, that vulnerability should be a separate and by reason of should not be included in relation to the hate crime category. I can't say one way or the other that one is better than the other in strict objective human rights standards. There is a lot of evidence that suggests by reason of is a much broader and more inclusive threshold that better represents how victims feel when they're targeted. Do you want to add? Emma is,
Yep,
may I just refer to, Emma has done a lot of the detailed work on this, and just in case I've made a hames of what she intended to say.
No, not at all. So just to re-emphasise that there is no human rights standard that says that by reason of should be included within hate crime legislation, but by representing different views, what our the Commission carried out research on racist hate crime in 2013, and what was coming through on that is that the grounds that already exist, which is the motivation by hostility or demonstration of hostility, that frequently demonstration of hostility was not being used as much as motivated by, and motivated by required, or the evidence to prove motivated by was more difficult to achieve. So a lot of the times the sentence enhancement was falling off. So the Commission were of the view then that if those thresholds that already exist were not working correctly, or were not working to the best that they could, then potentially then introducing this by reason of threshold to identify maybe potentially where there hasn't been a hostility but there has been a prejudice might be effective.
Right, okay. So if you were to add in is that the offence is aggravated by reason of, what you're basically, the way it's worded in 33 is that it may be specified as an allegation alongside a charge of an offence against a person A that the offence is aggravated by. So is that what we're talking about, leaving out aggravated by and adding in by reason of? Aggravated by reason of?
It's how you prove that it is essentially a hate crime within those thresholds. So there has to be a crime committed to start with,
Yep.
and then you have to establish prove that there has been an aggravating feature. At the minute, it's motivated by or demonstration of hostility. We're saying a third would be by reason of, and that would cover all the instances when a hate crime or an aggravating feature attached to a crime, a signal crime. As I understand it, the PSNI also think it would be easier to prove. That's not necessarily the decisive factor, but
yeah. So you basically be adding in, so at 33.1, it may be specified as an allegation alongside a charge of an offence against the person A that the offence is aggravated by reason of.
yes.
So you're basically adding by reason of, a reason of by the end of, on the end of 33.1.
I qualify as well, just sorry, our recommendation isn't that this should be added in. The recommendation is that the committee should satisfy itself that the legislation isn't lesser because it isn't in there.
Yeah, sure. Okay, I've got that. You also then talk about putting in a comprehensive definition then in part 4 of 33. Explain to me again why you think we need that comprehensive definition of hate crime, especially when the ministers went down the road of aggravating or aggravation on what is crime.
I think whenever people talk about hate crime, they have in their mind that there is a standalone offence which is called hate crime that can be prosecuted, and that's not the case. This is the aggravator model which was adopted, which is, we think, a perfectly good model. However, hate crime and hostility are not defined, and if you're going to prosecute somebody for aggravation, something is motivated by hostility, but there isn't a definition for hostility. It doesn't really help the police, it doesn't help the victim, and it doesn't help the perpetrator. So there is a principle that runs through all human rights law, that law has to be predictable. You have to know what you shouldn't do before you're prosecuted for an offence if you do it. So that it's partly certainty. There is, and it does provide, I think, that definitions may or will be provided either by way of regulations or guidance. We say it's always better in the enabling legislation that it's clear, particularly if you're creating a criminal offence. And it just makes it easier for, I think, victims to understand when a case may be treated as an aggravating factor. And it helps, I think, for judges as well, because judges, what they've told us in passing is that sometimes the aggravating feature is dropped because it's too difficult to prove. So rather than making it, rather than it dropping off, let's have a definition that says exactly what has to be established if you're going to prove it.
Okay, thank you. I'm going to put out to Patsy.
Yeah, thanks very much, Chair, and thank you for your presentation. Could I just say that it's unfortunately very topical that we're discussing this today in light of events this week where we had 27 people driven from their homes, and including a 2-month-old child, and we heard in the news this morning a nurse pursued by 4 masked men because of the colour of her skin. Now, clearly, I'm sure all of us, but especially myself, would want to make sure that there are no loopholes in the law for the sentencing of those individuals responsible for those criminal racist crimes. So can you just explain to me that by reason of what that adds to it to make sure that, should we put it, that the offence is solidified and very clear in law, that people responsible for any of those offences, whatever that might be, whatever prejudice or hostility or bias that might be, what does that by reason of add to that, please?
Let Emma go first, and then
Sure,
I'll
aye.
deal with the more general question.
Okay.
I think, again, just going back to really what we're saying about it, is that it's added as a third threshold, not, it doesn't become the only threshold. The thresholds that already exist, the demonstration of and motivation, still continue to exist. But by reason of would be that somebody is targeted by reason of their skin, of the colour of their skin, or by their race, or...
Can I maybe explain it this way? And this is why I said there are different views on this. You know, it has to be clear to protect everybody, and including for the police to prosecute it. But motivated by hostility is quite difficult to prove. You have to prove the crime is motivated by hostility. So there's different elements in that crime. The demonstration of hostility is another way of, essentially, it's sort of another way of proving motivated by hostility. But it's when somebody, for example, uses a racial slur in the middle of committing a crime, before, during or after, and makes it obvious that they've demonstrated that that is why they were targeting that person. By reason of allows more flexibility, and it allows more of the sort of surrounding circumstances to be taken into account. So there may be a situation where it's very difficult to prove motivation. It's very difficult to prove that anything was said demonstrably during the commission or after the crime, but it's, if I can use this expression, it's obvious, it's blindingly obvious to everyone, and it sort of catches those, but it should still be tight enough that it's not too subjective to a person standing by or a police officer, that they actually know what they're dealing with.
Okay.
Does that?
No, that's good, but
Unless-
sorry, did you want to?
I have a feeling Emma is going to say I've got that wrong.
No, not at all. Not at all. Just there are obviously, as Alison's been saying, there are counter views on this. This is not the only view, and because there is no standard in human rights law that we can point to say that this should be included, that's why we haven't included it as a specific recommendation that this should be included. There are contrasting views here. This is just one of them.
Just to get it clear in my own mind, the basis for which you're introducing this here, it's not based on a view, it's presumably based on legal advice, or...
Yes, it's the view we have reached, having weighed up all the legal advice, all the case law. We've, on balance, are of the view that it would add to it. However, we do think the law could currently be better enforced as it is, if there was a little bit more, and I say courage, as in prepared to run cases in front of judges rather than take perhaps an easy route out.
Okay. Right, thank you. Thanks, Chair.
Okay, Emma, Sharon, on the screen.
Thank you very much, Chair, and thanks to you all for the presentation and the written submission that you provided. I wanted to ask a question around not including misogyny. So I recognise that in your submission, and I had it up there in front of me, around the gender sensitive approach, and the fact that you've acknowledged that the experiences of women and men are different, and that you have to acknowledge that the different experiences and gender-based abuse. But I suppose given the context that we have here in the North, and the fact that most gender-based violence is as a result of misogyny, I wondered why you hadn't included that as a standalone aggravator.
We think it's sufficiently covered under the grounds of sex, and given the first crime, the commission of the crime that has to be proved. Do you want to, Emma? Or?
I'm happy to if you want
Yeah,
to.
you go ahead.
Again, it comes down to human rights law does not require there to be misogyny aggravator, but it does require that we don't allow discrimination on the basis of sex. So that's the more solid recommendation from ourselves. There's nothing to stop yourselves from going further than human rights standards. Human rights standards provide a floor of protection, there's absolutely nothing that would prevent you going further than that if you felt that a misogyny aggravator was a better level of protection. But what we have focused on is the protected characteristic rather than the motivation.
And perhaps the other point to mention is that this is also something in which there are different views amongst the experts who really understand violence against women and girls, and that sometimes having it prosecuted as misogyny as opposed to a crime which is aggravated can confuse matters and end up not prosecuting for the basic offence, which is the assault. When I say basic, I mean the underlying offence. So it can unduly complicate things when, in fact, it could be an aggravator if the attack was because the person was a woman. It's a difference to many of the violent offences against women and girls, when it can be very difficult to prove it was motivated simply because of their sex. It seems pedantic, and one of the reasons why we haven't said what we think is what we think you must put in the bill is because there is scope here for different views, and that human rights often, and in this area in particular, allows for different opinions, so long as the sort of basics are covered, and the basics are that people are protected and are that this sort of hate crime is prevented and punished if it happens, but getting it right, understanding why the offence was committed in the first place. So domestic violence, for example, wouldn't be, women may argue that it is necessarily misogynistic, but to prosecute every domestic violence offence as misogyny or having to prove it was motivated by hatred of women could be very difficult. So it's the nuances in there which can be difficult, and sometimes adding too much can undermine the effectiveness of what's already there.
Yeah, I appreciate where you're coming from there. I understand that. I suppose it would be our position that we feel like this is a missed opportunity in not including misogyny as an aggravator, because, and I suppose that goes back to the wider piece around the fact that we do have an issue with femicide and with domestic violence in the North, and we want to, the education piece, I think it's kind of integral. It's integral to the education piece to draw the line between misogyny as the root cause of that. So, like
we certainly wouldn't want to dissuade anybody from pursuing that and putting that in the bill if you think it appropriate. All I would caution is that some sort of careful thoughts given to whether or not it could actually confuse and not achieve the objective.
Yeah, no, I understand what you're saying. I appreciate the point that you're making. Going back to the earlier line of questioning around the by reason of, and I know I can understand completely the motivation there or the rationale for including that, but I'm wondering, is the practicalities of that, is that going to be difficult to deliver in practice?
It should be easier to prove, which is the practical application of this. If a criminal statute is almost impossible to enforce and almost impossible to get a successful prosecution as a result of, then it's not going to be very practical. So that's where we think the by reason of is an easier threshold, and it's a more inclusive threshold. It allows the police, for example, to introduce more evidence, sometimes circumstantial rather than just motivated by or demonstration of. But this is, like the last point, this isn't something that we can direct you to one or the other on. There are factors which you balance, and that's what's set out in this advice. I'd love to be able to say it was quite sort of cut and dry, but it's not. It's whatever is most suitable, most easily enforced, that achieves the very basic fundamental purpose of protecting people who are vulnerable or may be targeted because of their identity or characteristics.
Thanks, Alison. Thank you, Chair.
Okay, Morris, on the screen.
Thank you, Chair. And you call me just as I took a square of chocolate. Thanks very much for your presentation. I find it very interesting and slightly confusing. But you recommend adding both sex and gender identity as protected characteristics. But what evidence can you produce that the existing criminal law framework is failing to or will not protect victims in these categories? And what practical gap would these amendments address that cannot already be dealt with through sentencing and prosecution decisions?
Well, you could say that about all of the aggravating factors. Whether or not the criminal law deals with an attack on a person because of their gender identity is not really the issue. It's that if a crime is perpetrated on a person because of their gender identity, that is a hate crime and should have an aggravating feature. That sits very comfortably alongside all the other provisions, such as the European Convention on Human Rights, which protects against discrimination on grounds of gender identity. So we've stuck very much to those factors. It's also present in lots of other laws. So if you want to include protection for people who are targeted because they're transgender, then the aggravating factor should include that as separate to sex.
Okay, could I ask one more question, Chair?
Yeah, sure.
How would you propose the Assembly balances stronger hate crime protections with fundamental rights to freedom of expression, freedom of religion, and freedom of conscience, particularly where robust political, religious, or gender-related views may be expressed but are not intended to incite hatred or criminality? How would you propose the Assembly deal?
This won't apply at all. There has to be a crime. That's the first thing. If you're going to be prosecuted, the prosecution must prove you've committed a crime. They must then prove that crime has been motivated by hostility or involved demonstration of hostility, and that has to be proved to the criminal standard in front of a judge. And only then will it be taken into account in the sentencing. So it's not that you get a different sentence or have a different offence, although it is recorded that it is an aggravating feature. It's that a judge can recommend or can make a sentence which is at the higher end, so take it into account as something that makes the offending more severe. It's the sort of thing that judges do all the time. One of the reasons why this is specific to categories of protected characteristics and to aggravating features is that it wasn't being prosecuted, and judges were also complaining that it was being lost in the course of prosecution, so it was dropping off and we weren't getting a clear picture of how often this was happening. If somebody is expressing their opinion and they haven't committed a crime, then they have nothing to fear from this. And certainly the Human Rights Commission has always actively supported the right to free expression, the right to assembly, the right to political opinion. So expressing your political opinion is not going to be a crime in and of itself.
Okay. Chair, just one last wee point about sectarianism, and we have our own problems with sectarianism in this wee country of ours. So how would you define sectarianism in legislation without creating an overlap or creating confusion within the existing religious and racial aggravators?
We haven't unhelpfully suggested a definition. What we said is there should be a definition and it should be found. It is quite difficult to find somewhere that has relied on a definition of sectarianism. The Scottish model is quite helpful, but it is something that is, I'm not saying it's peculiar to Northern Ireland, but it is something that we tend to talk about more in Northern Ireland than other parts. So you can go by, there are various Council of Europe attempts at talking about sectarianism, and we've set out all of those. We can certainly, if advice was required on a definition which those responsible for legislation came up with, we could certainly help work through that. But unfortunately, I can't give you a cut and dry definition of sectarianism, and it is something that we accept is better, much better left to the legislators through democratic scrutiny.
I understand what you're saying. The definition of should be, I'm going for a walk this evening, it should be raining, it could be raining, or it will be raining, all means the same thing, it's going to rain. I'll leave it at that, Chair. Thank you.
Maybe just to, if there is a fear that it's going to further confuse, I think it's unlikely to make it more confusing. It's likely to make it clearer, I think, because so far what's happened is that it's been something that is sectarian has been prosecuted as a race or religion aggravating offence. The police record it separately as sectarian, so their statistics you can follow through as sectarian incidents or crimes. So it ties in much more neatly to the data that the police keep if we have a proper definition of sectarianism. But it is again, it's difficult. We're not suggesting it's simple, but we suggest that it should definitely be considered, and we leave it to you to work out the definition. But we can certainly help with that.
Okay.
Thank you, Chair.
Ryan?
Thank you, Chair. Thank you for your attendance on your paper. So you've said about wanting a definition of hate crime included. Now, the approach in the bill, I don't think the words hate crime appear in the bill. So, and you've said yourself, hate crime is currently not defined as a crime in itself. It's an aggravation on another offence, and the bill provides for that an allegation of an aggravation can be made, but the person can be convicted for the offence and the aggravation not proven. We're told that at 36. So the bill has avoided defining hate crime, and I presume for a reason, because they don't want it to be seen as a new offence. So so in that context, can you clarify what it is you're calling for? Are you saying hate crime should be a crime itself, or do you accept that it's an aggravator on another offence?
There are two approaches, and I'm absolutely straight out with you. There are two approaches, both valid. One is that hate crime should be a standalone offence. The other is that it should be an aggravated sentencing model. What we're talking about is actually something in between, in my view, which is that you're better explaining why there is an aggravation in a model. So something for which all the elements are capable of being proved, that goes together to make it a hate crime. And the police could record it as a hate crime. The court could record it as a hate crime. It's another one, however, and I hope this is not, you don't think we're trying to duck it, but unhelpfully we can't point to something where we say this is what it needs to be. There is a settled standard. Hate crime is something that is used so often that it is misunderstood, and I think a lot of people think there is a standalone offence, so you can go to court and be prosecuted for hate crime rather than component elements which together make up a crime which is aggravated by hate and recorded that way by a court. So it wouldn't be quite as simple as just adding a clause saying this is a hate crime, but it would be something that makes it clear, like almost a subheading in the bill. So hate crime, and then how you prove the elements of a hate crime.
Right, aye. Okay, no, I'll give it some thought. I'm just thinking about how the police describe things. They would describe something that I think they would use the term hate crime, or something being motivated by hate. I'm trying to think.
The police, yeah, it is. It's really, and this is one of the reasons why we say I wish we could come up with an answer, a clear answer for you. We can't, but the police will separate.
Something's been treated as a hate crime.
Yeah. And they will. But the thing is,
which isn't actually an offence. Then.
Well, this is where it gets very confusing, and where the statistics can be very difficult to follow. So a hate incident is recorded by the police as a hate incident. So it's reported as a hate incident because the perception of the victim or another passerby or the police officer is that it is motivated by hate, or there's a demonstration of hate on one of the protected characteristics. It will not be a hate crime unless and until there is a crime identified. And if it is prosecuted as a hate crime, the police have to show not just that there was a crime, but that it was motivated by or there was a demonstration of hostility. And at that stage, they have to prove it. So it's not enough just to rely on the victim. And this is where it can get very confusing for victims as well. So if they report it as, they will say, this was a hate crime. I am sure this was a hate crime and I was being targeted. The police will record it as a hate incident so that they don't lose any incident, and they can look back, for example, over their records to see if this person was targeted previously. They look for evidence. For it to become a hate crime, however, there has to be first a crime, but also they have to be sufficiently sure that they can establish that it was motivated by hostility or there was a demonstration of hostility, which is very different. And that's why a lot of these cases fall away at the prosecution stage, because they haven't been able to establish that it is a hate crime. It's not very clear the way the statistics are broken down. You have to be really scratch your head to understand the difference in those two. And it has led to a lot of, I think, probably unfair criticism of the police and misunderstanding by victims who think that their perception has not been taken seriously, and it's because it hasn't reached the criminal threshold for a prosecution to actually establish the hate incident of it.
Mm-hmm. Right. So if this went through as it is, something would be described as an offence aggravated by hostility, I think.
Yes, it would be the if I'm confused things more, no.
Okay. But
I always need to check I'm not making things worse. Yes, that's right. And also, I mean, primarily it's that when the crime is being dealt with, it's reflected in both how it's recorded in the court, how it's recorded in police statistics, how it's dealt with, and also the severity of the sentence. And it allows courts, apart from anything else, it allows courts, police and the criminal justice system to really monitor what's going on out there, because they can mark down this was something aggravated by, for example, racism or whatever it should be. Mm-hmm. We don't think this bill as it stands is going to be defective. So it's another example of where we think, in our view, having considered all of it, we're suggesting that the committee thinks about whether or not it might be better, and on balance I think we think it would be better. But we're not saying that this bill is defective if it goes through as it is. Mm-hmm.
And just to clarify, are you suggesting that hate crime should be an offence? Or do you accept the aggravator model?
Well, certainly on the basis of this, we accept it, and we can't point to something that says there has to be a standalone offence, no.
Mm-hmm. Okay, thank you. I think the rest of my questions are about clause 36. So you've made the point, 33 has racial, religious, sexual orientation and disability. So 36 is all about vulnerability. And in paragraph 7, vulnerable person is a person under the age of 18 or a person whose ability to protect himself or herself from violence, abuse, neglect or exploitation is significantly impaired through physical or mental disability or illness, old age, or for any other reason. So that captures the age, in that it associates age with also maybe frailty. So do you think that is sufficiently capturing the age factor?
In 36 we do.
Yeah, you're content with that in terms of capturing the age consideration, right? And in terms of paragraph 6, maybe this is more something for the department, just my understanding of this. I think this is to avoid double counting, so to speak. Paragraph 6 of 36, this section does not apply, this is about vulnerability, this section does not apply where the characteristic of the victim relied upon to prove that the victim was a vulnerable person at the time of the offence being committed is also an element of the offence. So, as I say, maybe that's more a question for it's just to understand what is meant there, whether there are certain offences which relate, and then you wouldn't add on the vulnerability aggravation, I think is what it means. But maybe it's more of a question for the department.
I think you could, I can tell you what I think what it's meant to include, but by no means limited to this. An example whereby sexual contact with a child under a certain age is an offence.
Right, yes.
It may also be an aggravating offence because of their vulnerability as a child, or an older person, likewise. I think that's what it's trying to cover.
Right, so it's not counted twice almost?
Yeah, I think that's my best understanding of it.
So just to clarify, so if someone was charged with child abuse, then this wouldn't come into play because they're already charged with child abuse?
Yes, it would be, the offence would already be taking account of the vulnerability, because it is a material part of the offence. Yeah. It can't be committed against somebody over the age of 18.
Yeah. Okay, go on ahead, Brian.
So one last question. You might have answered this already. We've already highlighted when we got the raised paper on this about sectarianism not being down, and obviously religious hostility is down in a Northern Ireland context. Whether or not religious hostility really captures, because quite often in Northern Ireland, sectarianism is about community identity rather than just religious identity. So just to clarify your view on that.
Yeah, no, we agree. And that's why we've pointed in this to, and we can pull it out together specifically on that if it would be helpful, but on the definition suggested by the Council of Europe, for example, looking at what sectarianism can mean, because you're absolutely right, particularly in Northern Ireland, it's not as simple as religion. There may be somebody who has no religion whatsoever, but they are attacked because of the perception of their religion or even political background. We have our own sort of way of describing it, which is different to most other countries in Europe, but following visits here, the Council of Europe and the UN, I think as well, had some working definitions for sectarianism, but I think people in Northern Ireland know better than anybody, including the Council of Europe, what will work for here, and that's why we've left it as that.
Have you included that Council of Europe in your paper?
Yes, it is in there. Yeah.
Okay, thank you. Thank you, Chair.
Okay, thank you. Doug?
Thank you, Chair. Alison, thank you very much. Look, I like looking at things through primary colours, and I like definitions. So therefore, I'm kind of supportive of a definition of the hate aggravator. But what does get me a little bit is why we need two. Because we've been talking about sectarianism, and sectarianism for me falls under the mantle of hate. There's no real difference in it if you look at it, and if you look at what you're suggesting in a definition of sectarianism, that falls onto what you're saying in regards to a definition of hate: bias, hostility, prejudice, bigotry, contempt. That could be religious contempt, community contempt, all of these things. Why would we need two definitions? I remember speaking to Judge Marinan about this. So why do we need the two definitions? Why can sectarianism not just fall under the mantle of hate, to allow society to move on slightly by normalising hate? If you mean, that's a strange thing to say, but I think you know what I mean, by normalising hate as you would have normalised hate anywhere else.
Yeah, I think that there are different things. So there's a reason why certain groups of people have protected, what's called protected characteristics, and it's because they have historically been subject to greater levels of abuse and discrimination. So the law has protected them specifically, and it sent out a signal that is particularly abhorrent if you attack somebody because of their personal identity. And it also has an effect on the wider community, because then all those people within the community are more fearful. And as Mr. McGlone said, at the minute, you can see that absolutely in terms of the race hate that's happening on the streets, the wider community are very fearful. So it's recognising all of that, and what it's saying is, if you commit a crime which you have committed on this person, you've singled out this person because of one of their protected characteristics like race, it has to be treated more seriously, because these people are more vulnerable. I don't want to use the word vulnerable because that's also in the Act for something else, but these people have been subjected historically to much greater patterns of. And so it's the same. It's been decided for decades now that some characteristics require protection because they are much more likely.
Sorry, Alison. No, I get that. I understand protected groups, and I understand why we need to do that. That's kind of not what I'm really saying. What I'm really sort of saying is it a far wider context here?
I think
is that the hate of somebody because of their religion. We'll call it sectarianism, but it's just hate. Why do we need to have a subheading to one? There isn't
a criminal offence which is hate. So you can hate.
No, aggravator.
You can hate anybody for any reason, and if you have it too broad, so if it's just hate for any particular characteristic, not one of the protected characteristics, it would be so broad it would apply to everybody, including one that's often, because I'm wearing glasses. You hate me. Somebody has a go because I'm wearing glasses or cut my hair colour or whatever. So this is very specific, that we are telling society that there are certain people who have to be protected in a slightly different way, and sending out a signal that society does not accept singling people out for something that is immutable is the word that's used, so not something you can sort of take off at the end of the day, or change your hair colour, or take off your glasses, for example. And it can be very difficult to explain the difference, but it's developed for a reason, and the reason is to protect particularly excluded or isolated or marginalised people.
And therefore what you're saying is that hate aggravator is really for the protected groups, but the sectarianism we're talking about is a wider societal piece then. That's because that's what we're saying here.
Well,
that one is just for protected groups and the other one is for wider society. But if I look at the protected groups, just because we've listed protected groups, doesn't mean that there's not other groups within that which aren't mentioned but will suffer the same thing.
Well, I'm telling you stuff you know well already. Northern Ireland's not broken down just into the two groups who would make up the sort of sectarian picture. It's relatively small, the numbers of people who are attacked because of sectarianism. And it's not simply because Protestant or Catholic or unionism, nationalism. It's identifying that a person has been singled out because of their community background and they've been treated differently because of their community background, and society still wants to send that message out. Historically, it was more significant here than it is now. The number of sectarian hate crimes is going down.
Yes.
But they haven't disappeared, and they do still occur. And I think it's to fill the gap between race and religion, because there are a lot of people who don't see what happens to them as a result of their of sectarianism as being a race or a religion issue. So it's to capture that. And also, for so long as the PSNI still continue to record it as an incident, a sectarian incident, then it has to be reflected somehow.
Yeah, and look, for an unfair answer, I'm not going to labour the point. I mean, like I said, I'm a fan of definitions. I really am. Yeah. I just don't want definitions for every single thing, you know. And that's kind of where I was.
It would be terrific if sectarianism was disappearing.
Can I ask you then a question? Would misgendering be an aggravator?
No.
It wouldn't be.
No, there would be no crime.
If there was sorry.
There wouldn't be a crime. So if you called me Mr. Kilpatrick, that wouldn't be a crime.
Okay.
If I was a trans woman and you called me Mr. Kilpatrick, that wouldn't be a crime.
Yeah.
There is no crime has been committed. If you committed a crime which was aggravated by which was motivated by hostility towards me because I was either trans or non-trans person, that could be taken into account in the sentencing, but that's not the crime.
No, I understand.
So that's
I'm just wondering, could that be an aggravator to that? Is the kind of the point
and it has to be. It's a level of severity as well. You know, misgendering is something that lots of people do very innocently for a variety of reasons. That this is not about capturing that.
And I think, and I ask that question because I think it's important, because there's a lot of people out there would think the opposite of that, and I mean, it's good to put that to bed, that people understand that they have that political and religious beliefs, and if that political and religious belief believes that there's only two sexes, then that's it. So that's why I ask, because I think that helps ease people's thoughts when it comes to this sort of things.
Yeah, and what's really important about this is to remember that this is about crimes committed by reason of.
Yeah.
Or I say that because I'm putting the two together, motivation or hostility. Nobody is suggesting, I don't think, that if a trans woman were to appear outside Stormont and she were attacked and physically assaulted and called names in the course of it, that the law shouldn't take that seriously, or a judge shouldn't at least remark on it in the sentencing.
Yeah, of course.
That's what this is about. It's not about creating offences where somebody may either be mistaken or be expressing a difference of opinion. And the Commission has taken steps in the past to protect exactly.
So that's very clear. Thank you very much.
Hey, Connie.
Yeah, thank you for coming in today. I think I wanted to pick up on what Brian was talking about on the definition of hate crime that you've recommended. And I know you didn't recommend an actual definition, but I did want to know what you thought of the definition that Judge Marnin included in his review. I think it was one of the first recommendations, and whether you think that would be appropriate in this bill.
Yes, he recommended it was prejudice bias, and have you got it there?
Yeah, I think I've got it in front of me. If that's.
Are you maybe quicker
Yeah,
than me?
no,
Sorry.
it's just perpetrated hostility,
we
bias,
don't disagree.
prejudice, bigotry, or contempt against the actual or perceived status of the victim.
We don't disagree with Judge Marnin on that.
You think that would be an appropriate thing for us to consider as a committee?
Yeah.
Okay, no, thank you. I think that's helpful just to have something concrete there. The other thing I wanted to then ask you about was in your evidence, I think it's at 2.58, you needed to capture multiple and intersectional forms of hostility, and that UN committees across the board have recognised that overlapping harms of multiple and intersectional discrimination. And in your view, how would you see the bill being able to do this more effectively?
You're never going to ask me back, because the answer I'm going to give you is that it's really difficult and there are different views on this, and there are still different views on intersectionality. There is the growing evidence and academic research is that recognising the fact that somebody can be singled out for multiple different reasons, but one particular feature is not the one which you can capture in the course of this, but it's a sort of combination of things. For example, one of the examples often used in court cases is a disabled black woman who can be discriminated against for all those reasons, or for one of those reasons, or might not be discriminated against at all and simply be the unfortunate victim of a crime. I do find it difficult to know how you would define this, but it is finding a way of the court recognising that there are some people who are so terribly vulnerable because of multiple different characteristics.
Do you think the bill, the way it's worded, would be able, that could be effectively included if there are multiple characteristics, the way that they're listed?
Yeah, I mean, the three of us here probably all have a slightly different view on how this could be done, which is why I'm not trying to force my view on anybody else. I think if cases are put together properly, if they're presented to a judge properly and prosecuted properly, a judge should be able to weigh all the factors in the balance, all the evidence. And if it were that intersectionality was recorded as something which the police had to take into account and a court had to take into account, they wouldn't lose any of those features which aggravated the particular sentence. So it could be racist, and excuse my language, this is the way I'm going to put it, only a little bit. And it's very hard to prove the crime was motivated by that. Yeah. It could be disablest, but only a little bit. That was only do you see the point I'm trying to make? So sometimes collectively there has to be a way of recognising that is the collective features of that person which has singled them out for a crime to have been committed. That should be able to be done just in the course of a proper prosecution if all the evidence is there, but often it's not. And we know how busy courts are, how busy prosecutors and police are, and sometimes it's easier if they're required to record from the outset. And if they would be required to record if it was in the bill, the intersect, that multi. I can feel your. No.
No, that's helpful. And I think my last question is on that is if you're aware of any other jurisdictions which use a similar aggravator model that you think capture that well.
Yeah, you've looked at all of them.
I'm not aware of another model that captures this. That doesn't mean that they don't exist. It's maybe something that we can follow up on if that's helpful. There are, like for example, the Equality Act in England, in GB, deals with where there's two forms of discrimination. Now, I don't believe that there's ever been a case taken under those measures, or but so that's not potentially very helpful, and it's also not hate crime legislation or hostility legislation. So again, it's not particularly helpful. But maybe that's something that we can go away and think about and come back to you.
Yeah, no, that'd be helpful. Thank you. Thanks, Chair.
It can be a complicating or even confusing feature, and as attractive as it first appears, it can be very difficult. Similar reasons to some of the other things I was saying earlier, where you have something which is very difficult to actually pinpoint, but there has to be recognition that somebody can be subject to lots of different forms of discrimination, which collectively make an even more serious picture.
And then can I add to that then? Can I ask then, do you think that someone could be in this course of sentencing or trial, and in sentencing that can be aggravated by both hostility with regards to, let's take your example, a disabled black woman, that can be aggravated by racial hostility and hostility towards disability, and the fact that the reason of them being vulnerable?
Yes, and I think a judge should take all those factors into account when just analysing the facts and getting an appropriate sentence for that particular person. So it could indicate that person is a risk not just to a section of the population, but almost everybody in society, because they're they have hostility towards multiple groups.
Okay. Ira?
Just thank you, ladies, so far, and it's quite interesting. But at the same time, it's like this, and it is a balancing act because there is kind of competing views on it. So I just want to kind of try and tie down something. By reason of test, you had mentioned in relation to motivated by hostility, evidence is difficult to achieve. Demonstration of hostility is not even really being used. So if this, by reason of test, is not included in the bill, how much is it going to weaken our ability to tackle hate crime?
It's not going to weaken it because it won't be removing anything that's there, but it won't be using the opportunity to strengthen it either, to include much broader, more realistic evidence, circumstances and evidence. So, and often you hear people often talking about how a hate incident or an aggravated incident is one that is motivated by hostility, and you very rarely hear anyone saying they can prove it on the basis of demonstration of hostility. So racist comments made during the burning out one of the houses, chasing a woman down the street, racist language was used. That would be demonstration of hostility, would be enough in itself, but you never really, the last time I saw a case actually reported upon where there were sentencing remarks, I can't remember when the last time I saw something with demonstration of hostility. And motivated by hostility, what you often end up with is in a courtroom, a defence counsel saying, you don't know what's in his heart, so how can you prove it's motivated by? But that's I'm not saying they all say that particular, but that's the way you would defend a case like that. So being able to put together more of a picture of all the surrounding circumstances and show that this was by reason of the fact that the woman you've chased down the street is a black woman who you think is a migrant.
Just secondly, just moving on in relation to the information that we currently hold and the prevalence of hate crime, and given the awful scenes that we've witnessed here today and over the past week, that is really concerning. Obviously, legislation is good and it's a positive step forward, but I'm worried about it needs to be the prevalence of it needs to be recognised. So what more needs to be done? Because you'd mentioned about, the police would record hate incidents per se, but they're not necessarily seen as crimes. So have you looked at how information is currently captured and how it could be improved upon and what is being captured?
All hate crimes should have started off at least as a hate incident unless the evidence of criminality was immediately apparent. So somebody reports an incident and they say it's motivated by hate on a particular characteristic. The police will put it down as a hate incident. So those statistics are always going to be greater than the number of crimes ultimately, because then when the police start to investigate, gather evidence, decide to charge or not, they will look at whether or not first there is a crime, and secondly whether they can prove it's been motivated by hostility or is accompanied by a demonstration of hostility. So incidence is to make sure that you don't miss potential crimes or patterns of things that you're not really sure there's a crime yet has been committed, but there's a pattern of behaviour, and it will flag up particular perpetrators. It will also flag up particularly vulnerable victims or potential victims. So it's to make sure the police are capturing at the earliest opportunity the patterns, the risks, to enable them to safeguard it. So it's not just prosecuting a crime. The police are already really actually pretty good at doing this. Their statistics, they were ahead of most other agencies in recording this. So they do record incidents based on perception and then crimes. What is less easy to get hold of is once it gets into the court system. So for example, once a person's been charged, whether they are then prosecuted, if they're prosecuted, what happens as a result of the prosecution, how they're sentenced, what did the sentence include an aggravating feature or not. That's almost impossible to get hold of, that information. I was working on this back in the mid-2000s, and it was difficult then, and it hasn't changed much. So it's the information really isn't being collected. That's why definitions and sometimes overstating things in legislation can be helpful, because it forces people to actually write down, this is this. That then gets fed into the system. But even if it is defined and is fed into the system, some kind of flag or marker or way of tracking these cases is really important. because what you will hear anecdotally is that however horrific the racist motivation, for example, is to a crime, when you get to court, that's somehow disappeared. And you will hear that an awful lot. And judges even will say that it's just not presented, even though they suspect it was a hate-motivated crime. So it's about everyone doing their part equally well, and recognising how hate based on hostility is dangerous for those people, dangerous for other people who look like them or are like them, and also for wider society. It helps identify those perpetrators who are really risky. You know, you need to know, and it's another way of, one way of looking at it is that police now know that if a man, for example, and you passed the non-fatal strangulation law, which was very positive, but if a man strangles or puts his hand on a woman's throat, that man is much more likely to go on and commit very serious violence on a woman, and also there's a greater link to murder as well. So it's like knowing that these are triggers or these are indications of what you're dealing with. So it is more work, it's much more work, but it's worth it, and all the evidence suggests that this really does work if you're careful at the beginning, but that you stick with it throughout.
Yeah. It's re-emphasising then we need to improve. The data's been captured, but it's not then being reported on.
It's been captured at certain stages, but not throughout the whole criminal justice system, and not so that you can actually track individual cases. And there's a way in England that they do, and I think it's called case through system tracking, something like that. I used to know what the name of it was, but it's where there is a marker attached to a particular case, and that case, so in this case it would be racial aggravation. And that will stay with that case throughout the whole system and throughout every computer record. So the police will record it at the courts. Even if it's dropped, it will be recorded on the computer system that it has been dropped and for what reason when it goes to sentencing or to trial. And that is a way you will really start to establish what really is going on here, because it's, at the minute, you could not say almost anything. There are some things which are incontrovertible, but there is a lot of speculation about what's going on and why things are dropping out, or why, more of this than that.
Okay, just two others. Obviously, Sinn Féin are very clear in relation to this, the crime legislation. If it doesn't include tackling sectarianism, it's fundamentally flawed, in our opinion. And it must go beyond, obviously, race and religion. How much of a gap do you think this leaves us here in the North in relation to these current proposals?
It doesn't mean it can't be prosecuted, but it does mean it's more difficult, I think, and less likely.
Okay, thank you. And just one final one. I always believe strongly in this, as members will know. You recommended a regular review of the legislation on hate crime provisions. How often do you think it should be reviewed, and who should carry it out?
Initially, I think as often as frequently as you can do it, because it's in the early stages. You can work out, has this achieved what you wanted it to achieve? Has it been worth all the time and effort we've put into this? So I think it needs to be, and you could, there could be an obligation on various agencies throughout to monitor. So it would be the police, the court service, criminal justice inspector could also look at this. They may be one of the best ones to do it, but all agencies involved should really, you would hope, be monitoring it, because they also want to know that their resources are going in the right places. Why wouldn't they want to know what's going on out there and what needs to be done to address it? But you could require it, and certainly the department would have to be overseeing all of that. But CJI might be. They certainly have superintendents over the criminal justice system, so they could, if they wanted to.
Okay.
Well, just on that, because I know Ciara's very hot on review, but we're also very hot on commencement. So Part 6 is commenced into operation on such days or days as the department may by order appoint. So do you have a time frame of when this should be coming into commencement in law?
No, I mean that's for you to sort out. I think whenever you reasonably, practically can do it, having gone through the proper democratic process. What we would say is that it shouldn't be delayed unduly, but we recognise that there are some tricky enough things that you're going to have to determine.
Yeah, so that's the political process with regards to the legislative steps. But even with that, this comes in, gets royal assent, this sits here in abeyance until the department decides to commence it.
I see what you mean. Sorry, I misunderstood the question.
The political questions will be asked and the process will be done. So after we've seen this go out through the door and it becomes an act, this could still sit uncommenced. Have you any time range on that?
No.
Or why would the department hold it up, I suppose is the question.
I don't know.
No, that's fine.
I'm not going to speculate.
Yep, that's fine, thank you. Is that you, Kieran?
Yep.
Yep, thank you. Can I ask questions? Alison, you said something earlier that has intrigued me, because I'm fascinated with the whole hate crime scenario. Hate's not necessarily crime. In fact, hate's not necessarily a bad thing. I hate child abuse. I hate sectarianism. I hate all sorts of things. And it's nowhere near a crime. And in fact, it's healthy to hate in those regards. So I have this real problem with the actual words hate crime, although I understand what it actually looks and feels and looks like. You said earlier on about if someone uses a descriptor in the course of a criminal action. So in a fit of rage, someone attacks someone and actually calls them by a descriptor. You Protestant B, you Catholic B, you black B, you baldy B, could be anything. Is that enough to convict somebody on a hate crime because they've used a descriptor?
No, it has to be, you have to establish that the crime is perpetrated by reason of, if you add in the third threshold, or that the crime has been motivated by hostility, or there is a demonstration of hostility which relates to the crime. If you're insulting somebody, calling them a pejorative name, if you dislike them for other reasons, and you utter that in the course of committing a crime, it's not necessarily the same thing. Mm-hmm. So demonstration of hostility, it's not just demonstration of prejudice, it's demonstration of hostility involved in that crime. So it is much higher than, and I understand, I'm sure we've all done it. We've used inappropriate language at times when, blood's high. But this is more than that. And if it's done right, everyone knows what it is they're talking about. And that's why we also say clarity for potential perpetrators, because it's if this becomes so wide and it can be used as a stick to beat each other, then it's not going to help those people who have been attacked as a result of hatred of their protected characteristics. So it should be sensible. And I'm not to say that's not to say there haven't been ill-judged prosecutions brought, but I don't know of any that have succeeded where it's been something like that.
Yeah. Okay. You're the Human Rights Commission, and it actually amazes me that you've stayed silent on some of the other clauses.
Okay. Give me one.
24, and we know the motivations of why they're in the bill, but determining the length of the custodial sentence, the actual fact, Article 7 is engaged, requires the offences and penalties to be clearly prescribed by law, accessible and foreseeable in their application, prohibiting retrospective imposition of a heavier penalty. And we have now incorporated steps that the court may determine the relevant custodial period by taking following steps. Any concerns around that?
There are a number of reasons why we weren't concerned about any of this. The main reason is that our remit is to advise in relation to what human rights standards require or should be put in place to protect human rights. Mm-hmm. Sentencing is something within which there is a huge margin of appreciation given to states, and you could not turn across Europe and find two countries that are the same. There are certain basic principles, which is that there has to be a certain degree of foreseeability, certainty. It has to be a criminal offence when you commit it if you're going to be convicted of and punished. So we confined ourselves just to Part 6 because there were things that we could say on that. In relation to all the other stuff, there's nothing that has jumped out at us that causes concern or that is left out. However, part of that is capacity. This is that would be a massive piece of work to reflect on all of it. There's nothing jumped out at us, but we're very happy if you direct us to any particular parts to go away and give specific advice.
Well, I suppose it's in the course of determining the length of a custodial sentence. Now, someone has to be found guilty. The judge then will make sentencing statements on that. But this seems to be something additional whereby we're actually formulating in law steps that are required then, 4 steps. So step 1, determine the sentence that the court would impose if it were imposing the specified custodial sentence on A in respect of the offence of not taking A's non-disclosure into account. And then, I'll not bore you because you'll be able to read it, but step 2, step 3, step 4. So that just seems to be different and a new method of sentencing. I can understand why, and I'm not saying I'm opposed to it, but I just thought that human rights would have it.
No, I mean,
would be engaged.
There is, contrary to what a lot of people think about what we say, it's actually not that prescriptive most of the time. Right. Sentencing is something which is left largely to the legislature, so long as it doesn't infringe some of the basic rights and principles under the European Convention on Human Rights. Mm-hmm. This is simply giving guidance, and guidance is always given in relation to sentencing, so you've got the sentencing guidelines. It's setting out more methodically maybe what courts should do when considering what sentence, but ultimately it's for the Act to and sentencing guidelines to set the way in which society has decided that criminality should be punished. Okay. Subject to, say, those some basic principles about you can't be sentenced for something it wasn't a crime at the time you did it. Mm-hmm. So retrospectively, things like that. And
then clause 29, the reduction in sentence. So flipping it over to the other side then, whereby someone does disclose and then they get a reduction in sentence. Not everyone in that family, the victim's family, may be happy with that. So I'm wondering, is there nothing to be said there with regards to a person's right to respect private and family life? Article 8.
I mean, there is. I can always find something to say about human rights that is relevant to everything, and you're absolutely right in the sense that there are human rights engaged in all of these processes, but whether or not human rights has any sort of influence on one way or another, that's a different matter, and we only really talk about those situations where we think human rights, there's either a concern over it or that they can be better protected. Where, and time immemorial really, throughout the whole, since people have been prosecuted through the criminal justice system and sentenced for things, these are issues that have arisen. There will be different people in the courtroom, all of whom have been affected by a crime, but some of whom will have no input whatsoever in the sentence. There's no human rights. I'm very loath to say this. So the Victims Directive, which is an EU provision, over which there's huge discussion at the minute on all of that, does say something about the right to be consulted, the right to have your voice heard, etc. if you're a victim. I'm not going to get into that today, but there is nothing on this that is either offending of human rights or requires human rights strengthening. Okay. But if there is something, if there was a sort of scenario or something that you are concerned about or think that we need to consider, we're very happy to do that.
Thank you.
And I'm sure in every piece of work we do, there's always going to be something we've missed that other people have spotted,
Can I jump in, Alison?
Yeah, sorry.
Just on clause 29, that is, forgive me if I'm mistaken, that's that would be Charlotte's Law in relation to Charlotte's Law, is it? Yeah. So the Commission has actually provided advice to the consultation, and we can fire that over to you if that's helpful.
Thank you very much. That would be really, really good. And Brian and Patsy has indicated to come in again. I don't want to go through a whole round too, so if you can be very concise and succinct with your answering or your questions, sorry, and the same then for the presenters, if that's okay. Brian.
I want to ask, why do you think the department did not include sex, gender-based violence against women as a hostility?
The simple answer is I don't know, and I've maybe not quickly enough, but I've learned not to judge.
Just with all the focus on ending violence against women and girls.
I honestly don't know whether. I'm sure they had their reasons, and I'm sure it was well thought out. So, I wouldn't want to sort of second guess.
I'm not suggesting this covers it, but on the section vulnerability, the last clause, it would be a bit of a stretch, but 36(7)(b), a person whose ability to protect himself or herself from violence, abuse, neglect, or exploitation and then it says physical disability, illness, or for any other reason. But I think it would be a bit of a stretch to say that would cover sex, but that hasn't been suggested to you.
No.
Right, yeah.
And I think
That's the only thing I think could be somehow construed, but
yeah,
it's a bit of a long-winded way to get to it.
I think it would, and it would have to say that women were vulnerable to violence by men because they're women rather than another. And I'm not going there today.
I mean, it's something obviously we'll take up
Yeah.
why it wasn't included.
But that's a very good point. So if sex was to be added, and it can work both ways too, I suppose. Mm-hmm. So that would cover misogyny, first of all.
Yes.
Should that be in 33, or should it be in 36, or should it be in both?
We say 33
Right,
because vulnerability is not, you're not vulnerable to protecting yourself because you're a woman. Women are more likely to be attacked by men or to be victims of violence. That's what the statistics tell us. Yeah. But that's not because they're more vulnerable to it. It's because of other, and that's where the hatred comes in, where there is a growing movement that we've all seen online, in particular of misogyny. And it's tackling that as opposed to an inherent vulnerability in being female.
Okay. Thank you for that. Brian, are you finished then?
Yeah.
And Patsy, you want to end quickly?
Thanks very much. It's back to the by reason of. I'm not asking you to fulfil your role here as police or PPS, but as you'll know, a lot of the hostility and hatred that has been generated has been online. So, say an individual, we take it to the offence bit, could the police establish then, it's all about motivation, as you quite clearly established earlier, online comments, narrative by an individual, and then offence committed, which fit the pattern, fit the profile. Do you feel that there could be considered as well by police and ultimately by PPS in establishing the motivation for an individual to engage in hate crime?
Yes.
Right, okay.
And more evidence is online. So people's actions, intentions are online rather than in the street.
Yes.
So previously you might have had somebody who used to walk down the street shouting at people or saying you shouldn't be living here. Now they might do it online. If they then go on and offend and pick out a person of colour, for example, and run them from their home, the evidence of what they're saying online about how these people should be removed from their homes, absolutely evidence.
That's grand. That clarifies that a lot for me. Thank you. Thanks, Chair.
Yeah. Thank you very much, members. Thank you very much, presenters. That was very, very good and a marathon run for you, but it was very informative. So thank you very much.
Here.
It is. You're here. You open the window.
Thank you for your time. If there is anything specific, please do come back to us.
Thank you for that
we'll be
offer.
happy
Thank
to.
you. Thanks, Patsy.
Okay, thanks.
Okay, agenda item number 5 then is Criminal Justice Sentencing Bill, etc., or Sentencing, etc. Bill, should say, written papers. 5.1, Belfast City Council response to the call for evidence. Can I remind members that at the meeting on the 14th of May 2026, members agreed to allow Belfast City Council to submit its formal response to the call for evidence on the sentence bill once it had an opportunity to ratify at their full council on the 1st of June, which would be after that call for evidence had closed. So can I inform members that the Belfast City Council has now submitted its formal response to the bill, which members can find on pages 46 and 47 of the meeting pack. Can I advise members that the Council's response focuses on clauses 37 to 39 of the bill? Can I ask members if they are content to note the submission or if any further information or clarification is required at this time? Members content?
Okay.
5.2 then is WRDA and Rainbow Project correspondence. Can I refer members to pages 48 to 49 of the meeting pack, which contains a joint correspondence from the Women's Resource and Development Agency and the Rainbow Project. Both organisations provided written submissions in response to the call for evidence and have written now to request an opportunity to provide oral evidence to the committee on the sentencing bill with a specific focus on aggravation by hostility. So can I suggest that this is considered next along with the other potential sessions if members are content? 5.3 5.3 then, consideration of oral evidence for the sentencing bill. Can I refer members to table pack for the relevant papers? Can I remind members that over recent weeks the committee has noted a significant number of responses to the call for evidence from individuals and stakeholder organisations. Can I remind members that the committee has heard evidence from the Probation Board and the Human Rights Commission here, and details of other sessions that the committee has agreed are provided at paragraphs 5 to 8 on page 4 of the tabled pack. Can I advise members that the committee now needs to determine what other organisations it wishes to hear oral evidence from and to assist or scrutiny of the bill. So can I advise members that at page 8 of the table pack, the committee team has prepared a table of organisations whom the committee may wish to hear from on various sections of the bill. So can I seek members' views on what additional organisations or individuals they wish to hear oral evidence from to assist the scrutiny of the bill? Can I advise members that it will be necessary to schedule 3 evidence sessions at each meeting in September in order to accommodate the evidence session and to ensure sufficient time for the subsequent deliberations? So if I can refer members, do you want to stop there? Yep. Yep. So are members content then with the table at Annex A on page 8 with regards to the list of groups and the parts that they focus on, and then the issues that might pertain to that? Connie, you want to come in?
Can I just check, did all those organisations request to brief the committee in their submissions, or were they just organisations that responded to the consultation? So I call for evidence.
Sure, just if I can answer, it's a mix of both. It's some of them have identified who you might want to hear from based on the issues that they've raised, but some of them have also asked.
I just asked as well, there was individuals that submitted evidence for the sentencing bill and I don't see any of their names down, and they asked to be on it, particularly around aggravators. I'm thinking of one such lady, Pauline Duddy, Jasmine Slaw, who we had the motion in the Assembly. The SDLP had put in a letter a request. I know myself we're meeting or separately, but it is in relation to aggravators for the sentencing bill, and she was due to meet the Minister yesterday on it, but it was postponed.
That didn't work. Yeah, it didn't work out. Yep.
Sure. That would fall into, I suppose, the next part that you just might go on to about things that aren't in the bill, and what the committee wants to do about them. Now,
so I suppose we'll go on to that conversation in a minute, Ciara, because you're quite right. You know, we need to deal with that. But are all members happy? Brian, you wanted to come in?
Yep. I know on a previous committee, it was on the Women's Right Network, and I had previously given evidence on gender issues. On race issues, the Northern Ireland Indian Nurses Forum have spoken up recently this week with the circumstances BG Josie, and they put out a very positive statement that they might be worth considering with a large number of Indian health workers here. And for Charlotte's Law, I would suggest families of the disappeared through Wave Trauma Centre would be relevant.
Okay, fair enough. We can look at those and see just... Clark, you want to come in at this stage on?
In terms of families of disappeared, the families of Charlotte Murray and Lisa Dorian are going to be coming in September. And directly, they contacted the committee directly, so that has already been agreed, and that will be arranged at a time that suits them in September to come in. With regard to the Women's Right Network and the Northern Ireland Indian Nurses Forum, those are... We haven't actually received written submissions, which is why they haven't been included in this. But I suppose it's for members to determine if they think there are gaps in evidence that they actually do need to hear from, even if we haven't got a written submission, and whether they want to reach out to those organisations.
Yeah. I think in terms of what's happened this week, you know.
I think on the stuff that's happened this week, that Northern Ireland Indian Nurses Forum, which I hadn't heard of before, Brian, so thank you very much for that. It might be something that we could reach out to see if first of all there's an interest from them to come, and if they would wish to come. There'll be a lot of nervousness around people in organisations this time, and what we wouldn't want to do is put them on a sort of pedestal.
I can reach out to them, or maybe in the first place,
just to see. And even if they don't want to give us something with regards to a physical presentation, even a written submission at this stage, maybe, even though the call of evidence is closed.
Sorry, Ciara, go on.
I was just going to ask, are we going to consider, like we done on the last bill, doing like a round table, inviting neighbourhoods, communities with an interest in it, where it doesn't feel a stop when they come to the committee, but they feel more comfortable having the general conversation on core parts of the bill? I don't know if that's...
Well, there was talk of doing something alongside the Victims Commissioner around that, but that's something we could tease out maybe over the coming weeks, if that's okay. So our members are content with the table on page 8, and
just one.
Sorry, Patsy.
One, please. Some of the names I'm not familiar with. So are we satisfied that the race issue is adequately covered within those organisations there?
No, absolutely not.
Yeah, okay.
No, I'm sure there's organisations, because I've heard people on, I didn't quite catch the names on the radio, articulating the situation. I think it would be remiss if we didn't invite someone from those organisations on. I'm sure the Assembly Press people will be able to.
And that's where that group, that Nurses Forum, might fall into that group.
We maybe draw a list up, because I know we've a very strong active ethnic minority groups in the city and Derry that have been quite vocal over this past week as well, and we've touched base with them. So just to make them informed of this, and maybe see if they're, even if it's I know it's late for written, but
so that you raise a very good point. But even if there is a big list comes forward around the race piece, that might be something that we could do around round table, rather than having them on a TV screen for everybody to see. Not that I would diminish them in any way, shape, or form, but for their own safety and vulnerabilities.
And considering it's about sentencing, they might feel they would rather a more private conversation.
Yes.
Yeah. Could I maybe just say then, Chair, I'm very conscious the elements of this bill affect so many groups and people in Northern Ireland, and we do need to be able to try and manage getting evidence from as many as possible in a way that means we can complete our scrutiny in the committee stage. Is it possible to come back to this with another table that maybe just indicates, because for me, those who have put forward a request to want to come to committee, I'd like to know if that was included in their evidence, those who have given evidence in our call for evidence, and then also groups that members have raised who maybe we haven't heard from as well, because obviously it's important that we hear from a wide range of contributors, but I just think we also do need to do it in a way that maybe is sensitive to people who might not want to come before here if you're dealing directly with victims and survivors as well.
Well, I'm happy enough for that, Patsy.
Chair, I'm just looking up there, like for example there's Northern Ireland Council for Racial Equality and Northern Ireland Council for Ethnic Minorities. They would, just as I heard them and read them, they would instinctively spring to mind.
So that's the obviously it'd be part 6 then that would apply. That what we've just heard today. I suppose part of the important part of the evidence gathering will be as well is that and to use the time wisely. If the aggravator is there for people already, they'll be probably in support of what's there. So it's to use the time wisely to hear what gaps are, what you think is missing, rather than just having to continually hear, we support it. Do you know what I mean? Because the time is so limited.
I get that, but it would be, given the sensitivities this moment in time, wouldn't like to think we missed anything, particularly now. So it could maybe be elaborated to them whenever they're given evidence. Please come along, and we want to hear, is there anything specific you feel that we should be dealing with?
And how it could be improved?
Invitation along that line. And I'm sure they'd want to come along and express their.
And you're happy enough that if need be, if the list is so excessive, then we will probably need an hour forum rather than set piece presentations, that we might go that route if there's a big number. Is that okay? With regards to the Women's Rights Network Northern Ireland, what's interesting about them is, as a women's group, they are probably on opposing sides to some of the other women's groups. So I think for balance, it would be good to hear from them also. Brian suggested those. If I've got the right group, hope I have. So that might be that might be the gap in that mindset that we need to pick up. Are members content then on this piece with regards to what's in the bill? And then we'll move on then to have a small discussion about things that aren't in the bill.
Sorry, Chair, can I just clarify what is it that you actually want us to do? Do we arrange what's here now, or do we pause at the moment and bring it back? Or you've raised organisations, the Women's Rights Network, the Nurses Forum, Wave Trauma Centre. Patsy mentioned Council for Ethnic Minorities and another group. So do you want us to write out to them in the first instance to ask for a written submission, or?
Yeah, I think so. I think that would be the first thing. And if there is a lot, but again, if members come forward with a lot of names, a lot of organisations, I think we will look then to try and cater for everyone, and that'll not be through committee meetings.
Around the age aspect of it, was the Older People's Commission on, didn't they submit?
They did, and they will be coming in. I'm just trying to get a date sorted for them. They were supposed to be here last week, but had to withdraw at the last minute.
Right.
So they definitely are coming in. So are members content with the table, or do we hold part 6 in case we get an influx of more organisations? Or do we go ahead and try and organise at least what we have down? Because I take it these people have submitted and have given their...
They've asked to come to committee.
Not all of them have asked. So they might. The reason why there's so many on the table is we might write out to them and they might say, actually, we don't need to give evidence. Everything's in our submission, so it's to try and capture that. But they are only the ones who've corresponded with us. So if somebody hasn't written to us and some of the groups named haven't, they'll not be on the list. So
it's really important that we hear from those, as you say, that aren't happy with the bill.
Yeah, of course. What's
missing from the bill? What's the unintended consequences from the bill? That's what I don't want to hear. A repeat of.
It's good. Yeah.
A written submission that's already telling us that they're happy with everything because we have it on paper.
I think we need to be really. I think we do. There's so many groups interested in this. I think we just need to make sure we're hearing the best possible evidence we have from our committee perspective. Because we could meet. We've only got a limited amount of time, and we want to do it as effectively as possible.
Yeah. Okay. So, are we content then with the table? Are we content that we reach out to ascertain if any of these groups would wish to give evidence to the committee in front of a full committee? And then we also reserve the right that if there's a big influx, if Ciara comes back with a list of 6, Connie comes back with 5, Brian comes back with 7, that if we need to, we can do some out with the committee.
Yeah, I think the ones that I would come back with, they wouldn't feel comfortable in coming to a committee to give evidence, but they'd feel very comfortable in an informal room with others to discuss the experience, how they view it, and better understand actually the bill.
100%.
It's the lack of understanding or having the ability to go through a bill and do that work. As for those who we really need to be speaking to, is those in the grassroots that are experiencing crime and experiencing the courts. And I know they're represented through representative groups, but it's really powerful when you actually hear people on the ground who've went through it and experienced it. And they're educated through that informal gathering of exactly what's happening as well, so they can feed that through to their peers in their own community. So.
Okay. So I would ask members then, if you have got ideas or lists, get it to us. And I think we will. That has to be in for no later than next week, because the committee needs to push on here with this. Is that okay?
Yep.
So then moving on then to, and I refer members to page 6 of the table pack, if you can go back on yourself slightly, which sets out a number of additional matters that have been raised in the evidence received by the committee. As the committee focus will be on the bill as introduced, and that is a very important line, it is unlikely that there will be capacity to consider any of these matters in detail, and the committee has also been advised that work will be taken forward to progress the issues at points 1 to 2. Points 1 to 2 is Jay's Law and Harper's Law. However, members may wish to ask the department to provide an update on any consideration being given on the matters listed at points 3 and 4. And if I direct you to page 6, you'll see a full list there. So we could, in the first instance, write to the department and ask them where are they in a lot of these. Some of these will be in the sentencing review that's currently ongoing. and some might be being advanced in other ways. But at least we'll know, and at least then we can also address some of the concerns of the people out there.
Okay.
I also, if I may, we look at the experience we've had with the Justice Bill, and I have no doubt private members will pick up a lot of this stuff too and work and run with it. Whether it makes scope is another question entirely, but there is a question as to what we can only as a committee look at the bill as introduced. If someone brings forward amendments, either the Minister or a private member, early enough, we may be able to look at it, but there's no guarantees. And it's really what we're really scrutinising as a committee is the bills introduced. So we do have a dilemma here with so much looking to be put into the bill. I think it should be left to private members to pursue and put pressure on the department, and we can do to a certain degree, but our main focus has to be on scrutinising the words on the blue pages. So are members content that the first instance we seek we correspond with the department on all these issues and ask them where they are with it all, or what their views are on them all? Are members content?
Yep.
Okay, we'll move on then. So can I then remind members that in their written submission, the Northern Ireland Commissioner for Children and Young People advised that they were not able to provide advice on the detail of legislative proposals contained within the bill due to resource pressures. However, they wish to draw attention to a number of matters to support our consideration and scrutiny of the bill. So at a very high level, these include whether the department has or will conduct a child's rights impact assessment of the provisions of the bill, to explore the circumstances where a life sentence for a minor could be imposed, and clarify whether under 18s are captured in what constitutes a serious offence under Schedule 1 of the Criminal Justice Northern Ireland Order 2008, and then whether the provisions relating to attacks on public workers could potentially criminalise young people in care. And finally, questions around the aggravators and vulnerability in Part 6 of the bill. So can I seek members' agreement to forward Nicky's submission to the department to request our response to the points raised at this stage? Members agreed? Okay, thank you. Moving on then, agenda item number 6, SL1 Special Educational Needs and Disabilities Tribunal Amendment Regulations Northern Ireland 2026. Can I refer members to page 51 to 86 of the meeting pack? Can I remind members that the Department of Justice proposes to make a statutory rule under powers conferred by the Education Northern Ireland Order 1996 and the Special Educational Needs and Disability Northern Ireland Order 2005. The rule will put in place new regulations to amend the Education Special Education Needs Regulations Northern Ireland 2005, which will allow reform of the Special Educational Needs and Disability Tribunal, introducing new processes for mediation in disputes and new rights of appeal. The rule is subject to the negative resolution procedure, and the Department advises that it is intended to come into operation on the 1st of September 2026. Can I remind members that at the meeting on the 30th of April, the committee noted the information on the SL1 and agreed to issue a call for views on the rule via Citizen Space. Can I inform members that no responses were received? The committee also agreed to write to the Department of Education to seek their view on the rule, and the department advised that it was content with the rule and that the SL1 and associated documentation are accurately aligned with the Special Educational Needs Regulations Northern Ireland 2026. The committee also agreed to write to the Committee for Education for their view on the proposed rule. The Education Committee has advised that their consideration of SEND regulations is ongoing. A final position on the Department of Education's regulations and subsequently the regulations proposed by the Department of Justice has not yet been reached by that committee. So can I ask members to consider if they wish to proceed with a decision on the proposed rule, or if they wish to wait until the Committee for Education has reached its position on the related regulations. So can I seek members' views?
It'd be foolish to continue until they've come through and wait.
I think I would tend to wait also, as Doug has said, just to see what comes back from the Education Department. or committee, sorry.
Okay, yeah.
So members content then with that approach?
Yeah.
Okay, thank you. So can I seek agreement to ask the Committee for Education to provide an update when it has reached its final decision? And then can I seek agreement to provide an update to the Department of Justice on the current position as we've just agreed? Okay, agreed. So agenda item number 7 then is Strategic Approach to Safer Communities, Organised Crime Task Force Strategic Plan 2026-27. Can I refer members to pages 87 of the meeting pack? Can I inform members that the Department has provided an update on work to develop a strategic plan to tackle organised crime in Northern Ireland? The Department advises that a strategic approach has been developed in consultation with Organised Crime Task Force partners, which states that it is a deliberate shift away from reporting on routine business as usual activity, which will continue separately, towards targeted strategic interventions designed to deliver greater impact. The Department has provided an action plan for the task force which sets out a programme of activity for the coming year and is designed to support collaborative progress and safer communities within existing budgets, whilst allowing time to consider wider strategic issues before agreeing a final long-term approach. So can I ask members if they're content to note the paper or if any further information or clarification is required at this stage? Content to note? Agenda item number 8 then is correspondence. Can I inform members that there's correspondence memo and 16 items of correspondence at pages 204 to 346 of the meeting pack. Can I advise members that I will draw their attention to 8 items and then members have the opportunity to raise any points. 8.4 then, can I refer members to page 115, which contains a follow-up review of the Criminal Justice Inspection Northern Ireland SIGINI on the implementation of recommendations in its 2023. I'm going to get on the right page here. Yep. So the follow-up review found that, on the implementation of recommendations in its 2023 review of probation-approved premises in Northern Ireland. The follow-up review found that some progress, particularly on the operational recommendations of the 2023 report, but also highlights its disappointment that work to implement the strategic recommendations in the review had not been satisfactorily progressed to ensure the improvements needed and the anticipated benefits were realised. So can I seek members' agreement to ask the Department of Justice and the Probation Board, the PSNI and the Northern Ireland Housing Executive for their comments and views on the follow-up review's assessment of progress against the 2023 report's recommendations. Agreed?
Agreed, yeah.
8.6 then at pages 157, which contains copied correspondence from the Health Committee to the Justice Minister requesting an update on the status of work relating to the Right Care, Right Person model. So can I seek members' agreement to request a copy of the Minister's response to the Health Committee when it's available? Agreed. 8.7 then, can I refer members to 159 of the meeting pack, which also contains correspondence from the Health Committee to the Justice Minister in relation to the commencement of Section 1 of the Mental Capacity Act, Northern Ireland 2016. The Health Committee has written to both the Health and Justice Ministers to ask for clarity on the timetable for implementing the Mental Capacity Act in full. The Health Committee has forwarded a copy of the committee's letter to the Justice Minister as well as the briefing paper by the Law Society which accompanied the oral evidence. So can I seek members' agreement to request a copy of the Minister's response to the Health Committee when available? Okay, agreed. 8.6 then, can I refer members to page 168 of the meeting pack, which contains a correspondence from the Committee for Communities, providing the committee with a copy of a briefing paper from Housing Rights to support homeless prevention in Northern Ireland. Can I inform members that the Communities Committee has advised that it has shared the paper with the Department of Health and the Department of Justice and asks each if there is any work ongoing in relation to homelessness prevention in the respective departments. So again, can I seek members' agreement to request a copy of the Justice Minister's response to the Committee for Communities when available? Agreed. 8.10 then, refer members to page 272, which contains a response from the Department for Communities to questions of future funding for the Prisoner Support Project, which the committee had raised following consideration of correspondence from Extern. So can I seek members' agreement to forward a copy of DFC's response to Extern for information? Agreed. 8.12 then, refer members to page 279 of the meeting pack, which contains further correspondence from Neurology Justice Collective raising concerns in relation to neurology recall, access to justice and patient safety. So can I advise members that the correspondence also contains a copy of the Health Minister's response to the group following the concerns that they had raised with him on neurology recall and the impact on patients and their families. So can I seek members' agreement to forward a copy of the correspondence to the Committee for Health for their information? Okay. And then 815, refer members to pages 329, which contains a submission from an individual setting out a proposal for reform of the Industrial Tribunal's Northern Ireland Rules of Procedure. The submission proposes closing an access to justice gap through the introduction of a power of reinstatement. Can I advise members that it is the Department for the Economy which holds policy responsibility for industrial tribunals? So can I seek members' agreement to forward the submission to the Committee for Economy for information? Agreed. Then finally 8.16, can I refer members to page 340, which contains correspondence from an individual to a private office of the Minister of Justice in relation to ongoing concerns that members will be aware of in relation to the Department's review of pre-release testing. So can I seek members' agreement to request a copy of the Minister's response to that individual? Agreed? Agreed. Okay. Can I ask members if they're content to note the other items of correspondence set out in the memo in the meeting pack, or whether there are any other comments they wish to make on any of them at this stage? Members content to move on? Okay. Agenda item number 9 is forward work programme. 9.1, committee's draft forward work programme. Refer members to the latest draft of the committee's work programme, which is at pages 348 of the meeting pack. Members will be aware that the Minister of Justice is seeking to introduce the Victims and Witnesses of Crime Bill on the 22nd of June. The committee will receive oral evidence from departmental officials on the 25th of June in advance of the second stage debate, which may be scheduled for the 30th of June. Plans for the call for evidence on the bill will be considered by the committee on the 2nd of July. So can I seek members' agreement to ask the Assembly Research and Information Service to prepare a list of key stakeholders or expert witnesses that the committee may wish to seek oral or written evidence from to assist its consideration of that bill? Agreed? Sorry, Clark, you want to come?
Yeah, just, Chair, to take us back to the discussion on the sentencing bill.
Okay.
And the thought has occurred to me that it may be necessary as we go along to actually hold more than one meeting a week. Because there is significant interest in this bill. So I know that members are thinking about who else they might want to hear from. While you're doing that, would you give some thought to maybe the best time that would suit if we were to have a second meeting occasionally, as we're getting to it? As I suppose the question will be, do you do that at the start and take the evidence and allow more time for deliberations, or do we cram the deliberations at the end? So from October on, do we do it in September, or do we do it in October, November time? So it's just a thought that members might want to bear in mind.
We don't want to scare you or anything like that, but if you give that consideration over the week, I think that would give the staff a good clear steer as to how they plan this in September, October, November, considering that we'll have this new bill also on the books. I don't know whether, and there's also another issue around availability of room maybe, so would Thursday morning be?
Thursday would probably be almost impossible, to be honest, because I think all rooms are used then. I think most other committees, when they're having extra meetings, will have them on a Monday or a Tuesday. The difficulty with that is streams, because we take 2 broadcasting streams for plenary on a Monday and Tuesday. And I'm aware that other committees, which is why I'm asking now, because I'm aware other committees are booking up now. Because every committee is going to be in the same position.
Yeah, sure. So it looks like Mondays and Tuesdays. So if you can come back with some sort of steer as to what you think is the best that suits you.
Well, whether it's Tuesday mornings, Monday mornings, lunchtimes on Tuesday.
You could do like 9 a.m. on a Tuesday to 10:30 a.m.
We can look into see if there's any rooms available. Like I say, I know that there have been booked up. Some committees are already starting to book those kind of things. Committees do get preference in these rooms though, so if they're booked by others other than other committees, then we can probably probably get
So like a
them.
Wednesday afternoon's out basically, because that's committee
Oh, yeah.
time.
Mhm.
Okay, right.
The reason why I suggested Thursday
Morning.
morning was because we're here Thursday afternoon.
I have a
And
committee.
it would
It's
get
Thursday
it was
morning,
on, but you'd have
Few
a committee
people
on.
do them
Ah,
Thursday
sure.
morning.
I'd have our committee too, sorry.
I know, understand. Okay, well, that's just a thought.
Start early and finish late.
That's just a thought to ruin your weekend.
That is as it happens. You know, probably
We do get
doing
the
at least
justice
3
bill out of the
sessions
room first.
anyway. But
3
yeah,
sessions a
it's-
week?
No, sorry, not 3 meetings.
Oh, right.
3 sessions.
All right, okay.
3 sessions in each
Done that with
meeting.
communities last year. We had 3 a week
Yeah.
up near the end.
Yeah, yeah.
It happens, folk. At the end of the term, it's going to be nightmarish, but it's just one of those things. Okay, so that's just a wee pre-warning from the clerk there, just to condition you for what's coming. Okay. Agenda item number 10 then, chairperson's business. I have no chairperson's business to declare. Agenda item number 11, any other business? Does any member want to raise any other items of business at this stage?
No.
No? Okay then, agenda item number 13 is date, time and place of next meeting, which will take place on Thursday the 18th of June 2026 at 2 p.m. in room 30 Parliament Buildings. And Emma will be in the chair, most definitely, for that. So make sure you're all here in attendance to support her. Okay, I adjourn the meeting. Thank you.
Committee Room 30. Sound. 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 Committee Room 30. Sound.